Hey guys, and welcome to today's video. Today we've got not just one hearing, but several, all centered around the same absolutely clueless defendant. And trust me, this guy is a goldmine of bad decisions. Not only does he attempt to fire his own attorney in the middle of the process, but he also goes as far as requesting a psychological evaluation on himself, which honestly might be the first sensible thing he's done in this entire saga. But before we get into the chaos, I want to take a moment to thank today's sponsor, Chapter. If you or someone you know is on Medicare, you probably already understand how confusing the system can be. Most people end up overpaying hundreds, sometimes even thousands of dollars every year, simply because they accidentally chose a plan that doesn't actually fit their needs. And that's not on them. It's the product of a system full of brokers who care more about their commissions than your well-being. That's exactly why I partnered with Chapter. Chapter was created after the founders watched their own parents get taken advantage of by this broken system. They decided it was time to give people a way to get unbiased, trustworthy help. When you call Chapter, you'll talk to a real human being who walks you through every Medicare plan available in your area and helps you figure out which one actually works best for you. No pressure, no sales gimmicks, just real guidance. And the best part? The call is completely free, with the average senior saving over $1,000 a year by switching to a better plan. This is one of those opportunities that just makes sense. So give Chapter a call at the number on screen or head to the link in the description and let them see if there's money you've been leaving on the table, or if you're already in the plan that suits you best. Huge thanks again to Chapter for sponsoring this video. Now, with that out of the way, let's dive into today's lineup of hearings and watch this defendant achieve a level of self-inflicted disaster that truly deserves its own highlight reel.
Could I have your name, please?
Jonathan James Winter.
All right, Mr. Winter, my name is Judge Hesslink. I'll be arraigning you this afternoon. That involves me reading the charges to you, then telling you what your rights are, and then addressing bond. I have with me on Zoom Mr. Brown as a defense attorney and Mr. Portier from the prosecutor's office. The charge in the complaint against you reads as follows. It says that on or about July the 10th of 2025 in Bagley Township of Otsego County, that you did commit the following two offenses. Count one is entitled breaking and entering a vehicle to steal property between $200 and $1,000. It says that you did enter or break into a Chevy Equinox, a motor vehicle, to steal or unlawfully remove property therefrom of a value of $200 or more, but less than $1,000, contrary to Michigan compiled law. That is a misdemeanor offense. It has a maximum penalty of 1 year and or $2,000 fine, or 3 times the value of the property stolen, whichever is greater. Do you understand the name of count one?
It's a misdemeanor count, correct?
That's correct. Do you understand the name of it to be breaking and entering a vehicle to steal property between $200 and $1,000?
Okay.
I just need to know if you understand that, sir. Not asking if you agree with it.
Yes, I understand.
All right. And you understand the misdemeanor maximum penalty is 1 year and or $2,000 and up to 3 times the value of the property, whichever is greater?
Yep.
All right. Count two reads as follows. It says that on the same date, time, and place that you did commit the offense of breaking and entering a vehicle to steal property less than $200. And that says that you did enter or break into a Ford F-150, a motor vehicle, to steal property or unlawfully remove property therefrom of a value less than $200. That also is a misdemeanor offense, but it has a maximum penalty of 93 days and or $500, or 3 times the value of the property stolen, whichever is greater. You understand the name of count two?
Yes.
You understand the maximum penalty for count two?
Yes.
All right. Right now you have certain rights as to those charges, and I want to make sure that you understand them so that you can make an informed decision in the future. You have the right to plead guilty, not guilty, or no contest. You have the right to an attorney to represent you, and you have the right to have a trial by a judge or by a jury. Mr. Brown is here to assist us with the attorney, and we'll talk about that in just a minute. If you wish to have a trial in the future, you also have the following trial rights: to see, hear, and question all the witnesses against you, to present witnesses and evidence for your defense, and to get an order from the court called a subpoena to require those witnesses to appear and testify. At trial, you could also testify, or you could choose to remain silent. And if you chose to remain silent, that silence could not be used against you. You'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof be on the prosecutor at all times. Finally, you'd also have the right to appeal automatically any error that happened at trial. However, if you enter a plea in the future, you may be limited to asking the court for permission to appeal. Do you understand all of those trial rights?
Yes.
Do you have any questions about any of those trial rights?
No.
All right. Mr. Brown, have you had a chance to speak to Mr. Winter about his right to an attorney?
Yes, Your Honor. He would qualify, and that information has been sent to Mr. Gilo's office.
Thank you. Mr. Winter, are you asking for court-appointed counsel?
Yes.
All right. I will approve that request. That request has been submitted to that approval will be submitted to Mr. Gilo, who's the supervisor of the court-appointed attorneys. He will decide which specific attorney will be assigned to you for your case. In the meantime, I'm going to enter a not guilty plea on your behalf in order to protect your rights until you have a chance to speak with that lawyer. I'm also going to set a pretrial conference quickly so that your lawyer can speak with the prosecutor and see if they can resolve the case quickly as well. Do you have any questions about those procedures, sir?
No, I just need to be able to talk to my attorney because there is extenuating circumstances.
Well, we'll get into that later. You don't want to talk about anything right now, Mr. Winter.
Yep, and that's why I've set a quick
Like I said, I'll
pretrial
talk to my
conference.
attorney as soon as possible.
I've got to give it to this guy every now and then. He actually shows a flicker of self-awareness. There are these brief, almost miraculous moments where he remembers that he has the absolute right to sit quietly and let his attorney do all the heavy lifting for him. And for a split second, you think, all right, maybe he's finally figured out how not to sabotage himself. It's like he tries to talk and think and breathe all at the same time, and his brain just throws in the towel halfway through. The words start tumbling out in the wrong order. The point gets lost. And whatever moment of clarity he had immediately dissolves into pure confusion. You can practically see his attorney die inside every time he interrupts. So with that roller coaster of competence and chaos in mind, let's see what the judge decides to set his bond at. Because if the court has been watching the same performance we have, this is about to get interesting.
Work and get it to Mr. Gilo's office, and he'll get that information to you, and then the attorney will contact you subsequently. All right, now that we've set those things, I will address bond. So what I'm going to do is I'm going to hear from each of the attorneys as to bond, and then, sir, I'm going to listen to what you have to say, if anything, about bond as well. So, Mr. Fortier, your thoughts.
Your Honor, I did submit a bond recommendation form. In there, I did request a $5,000 cash or surety bond. That's largely, I mean, it's a larger amount considering what he's charged with, in the fact that they're both misdemeanors. However, I'm requesting that amount partially based on the fact that these were two thefts within motor vehicles that were part of a string of essentially vehicle burglaries. And on top of that, his criminal history is quite extensive. It is listed in that recommendation form. He's out on parole for a home invasion second degree. So he's got a history of stealing other people's property. That wasn't even his first home invasion. He had another one back in 2008. So like I said, he's on parole for that. He does have a parole hold. I confirmed that with Agent Doug DeLeo with the Department of Corrections. So there is an administrative warrant that's holding him. So regardless of what the court sets the bond amount at, he's not going anywhere, essentially. So in addition to the amount requested, we are seeking that there be the standard conditions of bond, along with no drugs or alcohol, no illicit controlled substances, and then to not have any contact with Timony Bonifant or Mallory Bonifant. They are the two vehicle owners that are in this case, and then also not to return to the property of 19 Grove Avenue here in Gaylord. That's the property where the theft occurred.
All right, Mr. Brown.
Thank you, Your Honor. Mr. Winter is a lifelong resident of this county. He has ties to this community. I don't think he's going to go anywhere. Failure to appear is not really going to be an issue. It is my understanding he did, or possibly was arraigned yesterday on an FOC warrant. So I don't know if there's a significant bond in that matter as well. But as Mr. Fortier mentioned, he is on a parole hold, so bond is really not a huge issue, as he's not going to be able to bond out no matter what it is set at. But I would ask the court just to consider the charges. These are misdemeanor charges. Also, he did mention to me that he does have some mental health issues that he is taking medication for. I don't know what the jail's policy is or if he's getting those medications, but that is something that he requested, that he be provided any kind of medications that he needs. And then, again, I don't know who even has those medications. Thank you.
Those medications are here at the jail now, Your Honor.
Thank you for letting me know that. I appreciate it. Mr. Winter, you also have the right to speak to me about bond. However, I simply want to caution you not to make any statements about the underlying facts of this case, because we are recording this proceeding and I don't want it to be used against you in the future. Is there anything else, however, that you want me to be aware of in setting a bond?
No, Your Honor, I have to speak to my attorney about that.
So, he managed to luck out with a smaller bond this time around, but honestly, it doesn't make a shred of difference. The guy is already sitting on nearly a $5,000 bond from the friend of the court, which usually means one thing: he owes money. And not just a little. We're talking child support level. You've ignored this long enough. Now pay up money. So, despite the judge giving him a bit of a break on the new bond, the reality is he's not stepping outside those jail doors anytime soon. Instead, he gets to enjoy a front row seat on the express train to his next hearing, where things take a much sharper turn downhill, because that's where he gets arraigned on a fresh set of charges, the kind that aren't just inconvenient, but genuinely serious. The kind where even his attorney probably sighed before walking into the courtroom.
Sure, he can readdress that issue, and I'll consider it at that point. I would confirm, because Mr. Brown brought it up, there was a friend of the court hearing, I believe either yesterday or the day before. My memory is that there was a bond set in the amount of $4,900 that he could be released upon payment of that. I do not know whether that has occurred yet or not. So I
have not been able to do that, Your Honor. I'm not going to be able to do that.
All right. I appreciate that, Mr. Winter. Thank you. All right. In setting a bond, I am required to look at whether or not the person will appear as required, and then if there's any danger to the community. The prosecutor brings up history, and which is quite extensive, including resisting and obstructing convictions twice in 2004, larceny in a building in 2004, home invasion in 2008, prisoner in possession of weapons in 2013, and then a second home invasion, this time a home invasion second in 2019. Also, what the prosecutor alleges is a string of vehicle burglaries, of which this may have been a part. So for those reasons, I would need to believe that Mr. Winter might be a danger to the community. However, these are simply misdemeanor matters, and I do believe that $5,000 cash assurity is a little high on that end, given the fact that he has a parole hold and also an FOC warrant with extensive, a relatively large dollar amount on it. It's unlikely he's going to be able to post bond, so therefore I'm not going to set the bond in this matter quite so high. I will set it at because of his prior histories, I'm not going to give him a 10% bond, so I will set it simply at $500 cash or surety.
What's really unfortunate here is that this guy is almost talented at being terrible. He's so good at being a bad criminal that he has somehow managed to take what should have been a simple 365-day misdemeanor and escalate it into a situation where he's now staring down the barrel of a potential life sentence. And look, we're all adults here. We know he's not actually going to get life in prison for this. But that's not the point. The point is that Michigan does not mess around. They're one of those states where, if you keep stacking charges on top of stupidity, the sentencing guidelines start looking like a staircase straight to hell. And again, this didn't happen because the system randomly picked on him. This happened because he kept digging. Every chance he had to stop, he grabbed another shovel. Every time he could have just followed his lawyer's advice, he decided to go rogue. It's like he's speedrunning the criminal justice system on hard mode. And he's actually winning, just not in the way he thinks.
Your Honor, I believe that's Mr. Winter.
Is that Mr. Winter? All right. We'll change things here. All right, this is the state of Michigan versus Jonathan Winter, file 25-43924-FY. Can I have your name for the record, sir?
Jonathan James Winter.
All right, Mr. Winter, my name is Judge Hesselink. I'm coming to you from the district court. You're here today for an arraignment, so I'm going to tell you what you're charged with, tell you what your rights are, and then we'll discuss bond. The complaint that's been made against you reads as follows. It says that on or about July the 7th of 2025 in the city of Gaylord, Otsego County, that you did commit the following two offenses. Count one is named breaking and entering a building with intent. It reads that you did break and enter a storage shed located at 619 West Mitchell Street with the intent to commit the crime of larceny therein, contrary to the Michigan compiled laws. That is a felony offense. It has a maximum penalty of 10 years. Do you understand the name of that offense?
No.
What don't you understand about it?
What's the date of that offense?
The name of that offense.
Oh, I'm sorry, Your Honor. Yes, I understand.
All right. Do you understand the maximum penalty of that offense?
Yeah.
All right. Count two alleges stolen property, receiving and concealing over $200 but less than $1,000. It reads as follows. It says that on that same date, time, and place, July 7th of 2025 in the city of Gaylord, Otsego County, that you did commit the offense of receiving and concealing stolen property over $200 but less than $1,000 by buying, receiving, possessing, concealing, or aiding in the concealing of an e-bike, stolen, embezzled, or converted property, knowing that it was, or having reason to know that it was the property was stolen, embezzled, or converted, and the value was between $200 and $1,000. That is a misdemeanor offense. It has a maximum penalty of 1 year and or $2,000 or 3 times the value of the property, whichever is greater. You understand the name of count two?
Yes.
You understand the maximum possible penalty of count two?
Yes.
Calm down, little guy. Take a breath. Your court-appointed lawyer literally just found out he was assigned to your case about 60 seconds ago. He hasn't had time to read a single report, look at a single filing, or even pretend he knows who you are yet. You can't expect him to leap into action like some legal superhero when he hasn't even had the chance to sit down. Open the folder and realize just how much trouble you've managed to pack into one case file. This is the legal equivalent of waking someone up from a dead sleep, shoving them into a courtroom and asking them to explain quantum physics. It's not happening. Give the man a moment to get his bearings. He needs time to breathe, to think, to emotionally process the fact that you, out of all possible defendants, have now become his problem. Let him catch up before you start panicking, because trust me, he's already panicking enough for both of you.
For tier count two, I believe, is charged as a second or subsequent offense. Is that correct?
It is, Your Honor.
And then once that's done, that moves it from a misdemeanor up to a felony, and then both count 1 and 2, count 2 would be subject to the habitual offender fourth offense notice. Is that correct?
Correct, Your Honor. Both counts would be subject to that notice.
All right. So listen carefully, Mr. Winter. Count 2 right now was originally charged as a misdemeanor, but it also alleges that you have a prior, or at least one prior conviction, so that you would be a second or subsequent offender. And because of that, the penalty is increased to a felony level. So I want to make sure that you understand that. So count 2 starts out as a misdemeanor. It's alleged to be a second or subsequent offense by saying that appearing that on June 14th of 2012, you were previously convicted of attempting to commit, receiving and concealing stolen property, 200 or more but less than $1,000 in the 87A District Court. And therefore, this is alleged to be a second or subsequent offense. And because it is a second or subsequent offense, it is now a felony offense, which has a maximum penalty of 5 years and or a $10,000 fine or 3 times the value of the property, whichever is greater. Do you understand now that count 2 has been raised to a felony level offense?
Yes.
All right. Now, as to both count 1, which is a 10-year felony, and count 2, which is now has a subsequent offense notice, which raises it to a 5-year felony, there is also a habitual offender notice, habitual offender fourth offense notice, which also has the impact of raising the penalty. So I want you to listen carefully to this as well. It says that you are previously convicted of 3 or more felonies or attempts to commit felonies. In that on or about July 29th of 2019, you were convicted of the offense of home invasion second degree in violation of the Michigan compiled laws in the 46th Circuit Court for Otsego County in the state of Michigan. On or about April 4th of 2017, you were convicted of the offense of prisoner possessing contraband in violation of the Michigan compiled laws in the 46th Circuit Court for Otsego County in the state of Michigan. And on or about May 7th of 2013, you were convicted of the offense of prisoner possessing weapons in violation of the Michigan compiled laws in the 46th Circuit Court for the County of Otsego in the state of Michigan. Now, because these two, count 1 and count 2, both have a penalty of 5 years or more, the fourth habitual offender notice makes each of those a potential life felony offense. You understand the new maximum penalty on both count 1 and count 2 is now life imprisonment?
Unfortunately, yes.
All right.
All right, so that's the end of that hearing. The judge spelled everything out for him in terms even he couldn't twist into some grand conspiracy. Your record is long, your behavior is reckless, and your history shows you don't exactly treat court orders like optional reading material. So yes, your bond is going to be higher. That's not bias. That's not corruption. That's just the legal system reacting to the pattern you've spent years creating. Now it's time for him to shuffle back to his cell, sit on that uncomfortable mattress, and stew over the fact that no amount of arguing, interrupting, or courtroom theatrics is going to magically erase his past. All he can do now is wait for his next court date, which, conveniently, is where the story takes a turn, and not one in his favor. Because if he thought this hearing went badly, he's about to find out that things can always get worse when you insist on making them that way.
I just want to make sure that you understand what the charges are and what the maximum penalty is. Right now you have certain rights as to each of those charges, and I want to make sure that you understand each of those rights. You have the right to plead guilty, not guilty, or no contest. You have the right to be represented by an attorney in any of these proceedings going forward, and you have the right to have a trial by a judge or by a jury. If you, we're going to address your attorney in just a minute, but if you wanted to have a trial, you'd have the following trial rights. You'd have the right to see, hear, and question the witnesses against you. You'd have the right to present witnesses and evidence on your own behalf and get an order from the court called a subpoena requiring those witnesses to appear and testify. You could testify or you could remain silent, and if you chose to remain silent, that silence could not be used against you. You would also have at trial the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden remain with the prosecutor at all times. Finally, at trial, you'd have the right to automatically appeal any error. However, if in the future you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights that I've just given you?
Yes.
You have any questions about any of those rights?
That's why I talked to my attorney, Your Honor.
All right, that's a good idea. Mr. Brown, have you had an opportunity to discuss counsel with Mr. Winter?
I have, Your Honor. He will qualify. That information has been sent to Mr. Gilo's office. I currently represent him on another case. It is more than likely I'm going to be appointed to this one as well.
All right. So, Mr. Winter, what I'm going to do is I'm going to appoint court-appointed counsel for you, or approve court-appointed counsel for you. That information is going to be sent to the administrator who deals with court-appointed attorneys, who will appoint a specific attorney for you. That may be Mr. Brown because you already have a relationship with him. But in the meantime, until you have a chance to speak with that lawyer, I'm going to enter a not guilty plea on your behalf in order to preserve your rights. I'm also going to set a couple of quick court hearings to help preserve your rights. The first will be set within 7 days. That's called a probable cause conference. That's a chance for the prosecutor and the defense attorney to discuss the case and see if there's a way to resolve it quickly. I'm also going to set a preliminary examination within the next 21 days. That's a hearing in district court before me as the judge to find out if there's a small amount of evidence called probable cause to believe that you've committed the crimes that you've been charged with. It is not a determination of guilt or innocence. It simply is a check to make sure that there's sufficient evidence to proceed. Do you have any questions about those two hearings that we just talked about?
No, Your Honor, but I really need to have my attorney come here and talk to me way before any court date I have, because I have to talk to him about things that he needs to do for me that are very important and they are absolutely relevant